The following program was produced by the United States Courts.
Good afternoon and welcome to the Court AO Exchange program's Knowledge Seminar Series. I'm your moderator, Charlie Hall. Today we're going to give you an insider look at the United States Sentencing Commission and especially its recent changes to drug sentencing guidelines. So we're going to begin our program with a brief video introduction about the United States Sentencing Commission and what it does.
The United States Sentencing Commission is an independent agency in the judicial branch of government located in Washington, D.C.
It's a 7-person commission. It's comprised of judges, former prosecutors, defense lawyers. We even have a professor on the commission.
The 7 commissioners are presidential appointees, confirmed by the Senate for 6-year terms. At least 3 of the commissioners must be federal judges, and no more than 4 may belong to the same political party.
And our principal purpose is to set the guidelines for the federal courts that every judge is required to consider as a starting point in deciding whether and where to sentence a defendant.
That means the sentencing guidelines are advisory. Judges have the discretion to sentence above or below the guidelines if they feel it's appropriate.
The guidelines are central to the process of fair sentencing within the federal criminal justice system. Guidelines help ensure fairer sentencing, more uniform sentencing, and more honest sentencing.
This wasn't always true, but the Sentencing Reform Act of 1984 established the U.S. Sentencing Commission and helped eliminate regional anomalies.
The person who commits a bank robbery in Omaha would receive a very different sentence from someone who commits a bank robbery in San Francisco, even though they both have the same record.
Periodically, the Commission will amend the federal sentencing guidelines based on national data.
And the key part of what we do is we follow what the judges are doing, and we collect data from every single judgment for every sentence in the United States of America, or at least the ones that are required to be submitted to us. And so we really are at the crossroads of sentencing policy.
The data measures all aspects of the offense and the defendant's prior criminal history. The Commission uses this information to determine the new appropriate sentence range that the courts may apply.
It's important, I think, to have this information so that you don't just respond to an incident that receives a great deal of publicity, that the policy is actually based upon evidence over time.
Our staff, which is excellent, processes all that data, and it informs everything we do, from setting the guidelines to talking with Congress and the executive branch about what sentencing policy should be.
Ultimately, of course, any decision the Commission makes can be rejected by Congress. So when you have a bipartisan commission that typically acts by consensus, composed of people from all over the country with different backgrounds from different political parties, both Congress and the public, as well as judges, I think give it more credibility.
The United States Sentencing Commission provides certainty and fairness and is charged with the ongoing responsibilities of evaluating the effects of sentencing guidelines on the criminal justice system.
Judge Saris, I'm going to start with you, if you will. The video describes the Sentencing Commission as a bipartisan agency. Could you just tell us a little bit more about that?
I'd love to do that, Charlie. And I just wanted to start off by saying thank you to the AO for having this knowledge seminar, and thank you to all of you for coming. So I started when I was in my late 20s on the Senate Judiciary Committee as a young staffer with Senator Kennedy, and I started hearing the questions exactly the way you heard it on the video. Why should it matter whether you are committing armed robbery in California or Texas or anywhere in the country? Senators were asking, aren't we the same country? Why should the sentences be inconsistent? So Senator Kennedy, together with now Vice President Biden and Senator Hatch and Senator Thurmond, a very bipartisan group of people got together to pass the Sentencing Reform Act of 1984. It passed 100-0 and was bipartisan. And that's the statute that sets up the Sentencing Commission. And as you heard, we're also bipartisan, and we represent not just both parties, but also all the different geographic regions in the country. So we're from Alabama, and we're from California and Texas and the East Coast, Boston, New York, Washington. We also represent different backgrounds, prosecutors and defense attorneys and academics. We're named by the President and confirmed by the Senate. And we work together to try to come up with a guideline system which is consistent, proportionate, and fair, and eliminates unwarranted disparity. In the last year or so, we've been working on, last few years actually, have been fraud, firearms, child pornography, and violent crime. And wherever possible, we try and reach consensus on these important issues.
And can you just help us starting off to give us a quick sense of how do the guidelines actually work?
I'd be happy to. So let me start off. If no one's seen it, this is the most recent United States sentencing manual. A different one comes out every year. We, on the commission, look at crimes and we decide what's the appropriate level of severity, what's called the base offense level, and then there are things that you add on to it depending to determine the extent of the harm. Was there a gun? Was there a victim? Were you playing a minor role or a major role? And you decide what the offense level is based not only on that crime, but then after you've decided the severity of the crime, you look at criminal history. And because criminal history reflects, as well as we know how, the possible recidivism of the defendant. And then you come up with a sentencing range. And I'm not going to show it here because I don't think you could see it on the cameras, but basically there's a grid that is the starting point for every sentence imposed in this country.
And then one other thing, today we're talking about a very intensive process this last year of changing drug trafficking sentencing guidelines. So tell us a little bit about the amendment process generally. When and why does the commission consider going in and changing the guidelines?
So our amendment cycle begins in January when we propose amendments. And at that point, we will hold hearings, typically in February and March, and we'll hear from all the important stakeholders. We hear from Congress, we hear from judges, we hear from prosecutors and defense attorneys at these hearings, and we get input from all the stakeholders. And then, generally speaking, in April, we will vote for amendments, but that's not the end of the process. We send it up to the Hill on May 1st, and they do not go into effect until the Congress has had an opportunity to look at them, and if they disagree with them, Congress has the right to reject them by November 1st. But during that time, while we're waiting for Congress to look at it and see if they agree with it, what we will do is also have our priority sessions. So we'll try and figure out, well, what should our priorities for the following year be? And in that sense, we will also get comments from all our stakeholders, and we will publish a list of priorities. So once November 1st comes around, during that period of time, we start all over again with the next amendment cycle.
Great, thank you. Judge Hinojosa, from your perspective, have sentencing guidelines made your work as a federal judge easier or harder?
Well, sentencing will never be easy. I've been on the bench 31 years, and it's not just on the commission. I'm probably one of the few judges left who still has sentenced under the prior system. And it was difficult then, and I was 33 when I became a judge, and I thought this would be an easy thing to do. Somebody's committed a crime, they need to be punished. But then you realize that it is a very difficult thing to do, and it was then, and it continues to be now. Not only because you have a defendant in front of you with family and other background situations, but you also have to worry about the public and public safety. And a lot of times in federal court, the public isn't present. But as has been said before already, I had a wide range of probation to maximum on any case, and it was going to be just whatever I thought at that particular point, and I didn't have to do much of an explanation. The sentencing guidelines came into effect for a very good reason, the disparity that had occurred across the country with regards to judges with different individual viewpoints. And the one thing that I think is never really considered or not considered enough is the wonderful attitude that is brought by the sentencing guidelines from the standpoint of transparency. The idea that the judge has to explain factors that would normally be considered by a judge prior to the sentencing guidelines. In drugs, for example, the amount of the drugs, whether a gun was present and used. And now we actually have to have an open discussion with both sides being able to respond. And so that transparency, I think, we don't think enough of as to what the sentencing guidelines have done for the system from the standpoint of becoming fairer.
The focus today is going to be on the process this year of changing the drug sentencing guidelines. Are drugs a new issue for the Sentencing Commission, or is this something you've looked at over the years?
Drug trafficking is not a new issue for the Sentencing Commission. It was an issue for the very first commission that was established by the Sentencing Reform Act of 1984. And just to clear up something, in the federal system, unlike the state systems, it isn't that individuals that are charged with drug violations are people who are having personal use amounts on them. These are individuals who are involved in actual drug trafficking, many times with large amounts of drugs and different types of drugs. And so, and it's always been the major part of the highest percentage of the cases, although immigration now is equal to it, in the federal docket, and certainly it was that way in 1984. It was complicated a little bit for the original Sentencing Commission because of the fact that after the Sentencing Reform Act of 1984, before the guidelines were actually written, came the Anti-Drug Abuse Act of 1986 that instituted mandatory minimums for different types of drugs in different amounts based on the type of drug. And it would have been nonsensical, in my opinion, for the Sentencing Commission to have ignored that Congress had just spoken, basically the people had just spoken with regards to certain penalties, and the Commission at that point proceeded to use common sense and say, well, the drug trafficking guidelines have to be applicable under the statutes, and therefore the penalties should be equal to what they are in the statutes, and that's what the Commission did, and they tied them to the mandatory minimums based on quantity and the type of drug.
And one other thing I want to ask you about is the difference between crack cocaine and powder cocaine. Is that something the Commission has considered in a previous cycle?
I think that the issue of crack cocaine is one that the Sentencing Commission can be very proud of the way it has handled it. The disparity between the ratio for crack cocaine occurred as a result of one incident that we all remember, unfortunately, those of us that are older. It was Lynn Bias, who was a draftee by the Boston Celtics, whom I'm sure that Judge Saris is a big fan of the Celtics. But his death was caused by the use of crack cocaine. There was a reaction, and it's an example of how we should never react to one incident and then jump into something without really seriously studying the consequences and how it is affecting the public in general. And the ratio became 100-to-1. The Commission in the 1990s bravely decided that they were going to change the ratio on their own from the standpoint of the guidelines, and they were struck down. 1 or 2 times the Commission's work has been struck down by Congress. But the Commission didn't stop at that, and then in 2007, we actually went a step further and actually reduced the guidelines for crack cocaine within the mandatory minimums, and continued to urge Congress. We actually have sent 4 reports to Congress and held numerous hearings on this particular subject, and Congress did listen, and in 2010 actually changed the ratio from 18-to-1, and there may be disagreement as to whether that's the appropriate ratio, but nevertheless, it's quite an improvement from where it was before, and I think the Commission can be very proud of the work it has done with regards to that particular issue.
In 2014, again, drug sentencing really became the central focus of the Commission. And as a result of work the Commission did, sentences have been reduced, and tens of thousands of federal inmates stand to be freed from prison earlier than they might have. So, Judge Saris, in terms of public impact, is this the Sentencing Commission's most significant amendment to the guidelines, would you say?
Well, I've been chair for 4 years, and it's certainly the most significant thing that I've done or the Commission's done while I've been there. I mean, at our hearings, year after year, we were hearing about the problems with the expanding prison population. And it's part of our mandate to make sure that the guidelines minimize the likelihood that the prison population exceeds capacity. And a key piece of that prison population involved drugs. And I think you have a slide up there to show the dramatic increase in the number of drug trafficking cases. From 1992 to 2012, they increased by 79%. And then with respect to the next slide, I think, there we go, the drug trafficking offenders are about 33% of all offenders sentenced by federal judges, but they're more than 50% of the offenders in federal prisons. And this has an effect because the population has expanded almost 3 times what it was in 1991. Federal prisons are 32% over capacity, and federal prison spending exceeds $6 billion a year, making up more than a quarter of the Department of Justice budget. So these overcrowded prisons are expensive, less safe, and less effective. So we went about doing, based on our data, our extensive data, and our research, including our studies of recidivism on crack cocaine, and decided that it was time to take a new look at the drug trafficking guidelines.
I'm going to take a word you just used, recidivism, and turn to Judge Jackson. My understanding is the Commission actually studied recidivism data. Can you tell us a little bit about this and what role does it play in the process?
Yes. As Judge Hinojosa mentioned, in 2007, the Commission took a step to reduce the penalties applicable to crack cocaine offenders. There was a 2-level reduction, and having made that change, the Commission saw an opportunity to research the recidivism rates that were applicable to those offenders and to similarly situated offenders. The Commission actually followed 2 groups of crack offenders for 5 years. Those offenders who had received the reduced sentences pursuant to the Commission's retroactive application of the crack amendment, and also a group of offenders who were very similar but who had been released the previous year, and so therefore they had served their entire sentences. And the Commission's study of those 2 groups over the 5-year period revealed that there was no statistically significant difference in the recidivism rates between those 2 groups of offenders. And these findings suggest that the modest reductions in drug sentences actually don't make offenders any more likely to commit new offenses upon release. And the data also showed that plea and cooperation rates among crack offenders remained essentially constant after the 2007 reductions. And so that suggests that the kinds of reductions that the Commission did with respect to crack offenders don't decrease cooperation or hinder investigations.
Great. Commissioner Barco, we've heard a discussion about prison populations, now also about recidivism. What else did the Commission look at in your review?
So in addition to that, we look to see whether there have been any statutory changes or other guideline changes that might influence how we want to think about the guideline under study. So in this context, when the drug guidelines were initially promulgated, there was only one what we call special offense characteristic or enhancement that would distinguish among all the drug offenders. But now there are 14. So we have a lot more ways to break down that population of drug offenders without having to rely so much on quantity to draw distinctions. So that was a change that we noted. We also looked to the fact that when the initial drug guidelines were promulgated, that commission had set the guideline above the statutory mandatory minimum in order to create some space for offenders to plead guilty and get a benefit or to cooperate and get a benefit. But since that time, Congress has passed what's known as the safety valve, which gives a much greater benefit for individuals who cooperate or plead. And so it became less important to have the guidelines above the minimum amount. The other thing we look at is we look to see what judges are actually doing. So if you looked at the 2012 data to see where judges were sentencing, they were sentencing below our guidelines. And so what we do is we look at all these things, the recidivism data, the prison population data, the things I've just mentioned, and we were able to determine that we could lower the guideline range consistent with public safety so that it could better reflect what judges apparently believed were fair and appropriate punishments.
Great. Judge Jackson, anything else in the process that you considered as a group?
Well, in addition to the data that was mentioned, we also looked at public comment, and we listened to input from a number of different people. In fact, the Commission received more than 20,000 letters when we were considering making this amendment, and we also held a public hearing in which many people testified.
I'm going to throw in one question that I got after we talked this morning. Who reads these 20,000 letters? That's a lot of correspondence from the public.
Well, we have a fabulous staff on the Commission, and they do a lot of hard work looking at the letters and summarizing them.
Okay, good. I was going to say that.
Summarizing them. Thank you.
That is a good thing to have.
And they always give us representative samples of kinds of letters and tell us how many are sort of in that ballpark.
I see.
And
Okay.
taking that point of view.
Okay,
So.
super. Am I correct in a mix of like family members and then advocacy groups, that kind of thing?
Members of Congress. Yeah.
All right, okay.
And some groups actually have a letter writing campaign. And
I
so
see,
that
okay.
becomes evident. Sometimes a lot of the letters are the same form letter, but they're all very helpful.
And we do read the comments ourselves directly, things like the letters that are a little more duplicative, where it's a group where you might have a similar letter of a type, that's where we rely heavily on the summaries, but certainly we read personally the in-depth comments that we get from various groups.
We're going to actually use the video, or go back to the video again. There was a reference to all of this public testimony, and in March, the Sentencing Commission actually held an initial hearing on whether to reduce drug sentencing levels. So we're going to look at the video and see some of the testimony from that.
The department strongly supports the Commission's proposed change to the drug quantity table. This straightforward adjustment to sentencing ranges, while measured in scope, would nonetheless, I believe, send a strong message about the fairness of our criminal justice system. And it would help to rein in federal prison spending while focusing limited resources on the most serious threats to public safety. As it stands, and as this commission has recognized, certain types of cases result in too many Americans going to prison for too long, and at times for no truly good law enforcement reason.
But I'm pleased to be able to say that FAM supports your proposed amendment wholeheartedly. We do view this proposal, though, as a very modest proposal. It's definitely not a major shift in policy or policy change.
They have found terrific support from all components of government, from both parties, from all sorts of stakeholders across the spectrum. And that support is coming in large part because the crime rates keep dropping. I think we're finding that the reason the crime rates are dropping even after these penalty adjustments have been made is that incarceration is something that has diminishing returns.
We know that drugs are pernicious substances and that they're fungible, and once they're introduced into the community, they have a ravaging effect upon the populace, especially in inner city and minority areas, where African American males are 5 times more likely to be murdered than white males. That's why these laws are tough.
I am keenly aware of the terrible harm that drugs can cause, the devastation it can cause to the victims, to the families of victims, and the community at large. So I am mindful, and I know we all are mindful of that.
Judge Jackson, when you look at all of this, the letters, the data your own analysis showed, and then the testimony, can you summarize all the main pros and cons of changing the sentencing guidelines?
Yes, I mean, we heard from individuals and groups on both sides of the issue. I will say that most of the testimony and the public comment that was submitted was in support of the amendment, but we heard from, as you saw, the Department of Justice, senators from both sides of the aisles, civil rights organizations, sentencing reform organizations, and at one point on the clip you saw a representative from the politically conservative criminal law reform group known as Right on Crime. And in general, the supporters argued that reducing drug sentences would reduce prison spending and overcrowding, that it would free up money for other more effective criminal justice priorities, that it would help address budget shortfalls and increase trust in and cooperation with law enforcement in certain communities. And, of course, there was the argument that it would lead to more just results, and all without harming public safety. There were organizations and individuals who opposed it, including some national prosecutor organizations, some in law enforcement, and the chair of the House Judiciary Committee and ranking member of the Senate Judiciary Committee at the time. And the arguments in opposition generally were that reducing drug sentences would had the potential for undermining public safety, and in particular threatening the reduction in the crime rates that we've been seeing recently.
In April, the Commission unanimously voted to reduce the sentencing guidelines for drug trafficking offenses. I'd like each of you to take 30 or 40 seconds to tell us why you personally voted for the amendment. If I could start with you, Judge Saras.
Well, thank you. Yes. So the big issue we had on our plate was our statutory mandate to make sure that the prisons weren't overcrowded. However, we also are greatly concerned about public safety. After all, in the 70s and 80s, people's concern about crime was huge, which is one of the reasons why these statutes have been passed. So we needed to come up with the right balance. And for me, what was very helpful was not only the data that the commission came up with on recidivism with the crack cocaine, that was very helpful, but since this was more of a drugs minus 2 across the board, I wanted to know what was happening in the states. Many of the states have already done this, and they've done it without an increase in violence. And so for me, that created the opportunity to have a reduction in the amount of the penalties.
Judge Hinojosa?
Well, this goes to show you how we can have regional differences and why it's good that we have a national commission. Although I had been very supportive of the crack reduction, I had been hesitant in the past with regards to reducing all the rest of the drugs, mainly because I was born and raised on the southwest border, right on the border with Mexico, and the drug trafficking issues that have developed on the border on both sides, and the harm caused to both countries, especially those of us who were born and raised on the border and no longer cross when it would be an option for dinner if you came to visit us in McAllen, Texas, but it no longer is possible because of the violence in Mexico as a result of the drug trafficking and the drug usage on this side of the border. However, I was convinced because of the study that we did with regards to crack cocaine that the recidivism rates are no different if you lowered the penalties by 2 levels. And I also was convinced that this was appropriate because we're still within the mandatory minimums of Congress. At the 10-year minimum, instead of 121 to 151 months, the guideline range is at 97 to 121 months. And at the 5-year mandatory minimum, instead of 63 to 78 months, it's between 57 to 71 months. And I felt that it was still giving due deference to the congressional viewpoint.
Judge Jackson?
Yes, I think in addition to the public comment and the recidivism study, both of which were very important, I was also persuaded by the fact that it was a modest 2-level reduction in the base offense level for drugs. This meant that the commission was estimating that 70% of new drug offenders were going to be receiving the benefit, and that they would get sentences that were 11 months or approximately 17% shorter than before. And so we weren't talking about a dramatic decrease. And that I think was very important. And of course, I considered the views of my fellow commissioners because we like to operate by consensus. And so I was very persuaded as well by what other commissioners said.
Commissioner Barkov.
So I'm persuaded by all the things that my colleagues have just said, and they echo my own thoughts as well. And the only thing I would add to that is I do think it's important for every agency to really assess their regulations and make sure they're making sense, and that's true for the commission as well. And it's just a matter of good government practice to make sure you're using resources effectively and efficiently. And all the data in this context pointed to the fact that you could free up this prison capacity in this space and not do it at the expense of public safety. So just as kind of good government rational decision-making, it made sense to me to do this.
Before we move on, I want to ask one simple math question. A number of you talked about reducing the sentencing by 2 levels, and Judge Hinojosa gave us a number of ranges, but on average, how much of a reduction in time served would this change lead to?
Well, I mentioned it's approximately 11 months,
yeah,
or 17% reduction, and what that meant was that when you looked at all drug offenses combined, the previous average sentence was 62 months, and with this reduction, the average drug sentence will now be about 51 months, the commission is estimating.
Great, thanks. Okay, so this actually was the first of 2 processes that the Sentencing Commission went through this year. One was to simply decide whether to change the sentencing level, but then you had to look at a second question of retroactivity. And Judge Hinojosa, I was hoping you could explain to us what retroactivity means in this context.
Well, I think it's important for us to note that after Booker, the guidelines are referred to as advisory guidelines, but when it comes to retroactivity based on the statutes, anything the commission does really has statutory authority and is not advisory. And Title 28, Section 994U, the statute that set up the Sentencing Commission, says to the commission that any time it reduces penalties within the guideline ranges, it should consider as to whether it should apply retroactively. And then Title 18, Section 3582 tells those of us that are judges that if the commission does do that you can reduce the penalties if you so desire as a judge and find it appropriate under the factors we consider, but you are limited by what the commission has done, and you have to follow whatever the commission has done with regards to the ability as to how far you can go. And so The commission itself in the manual has given three ways as to how, three factors that it considers as to whether to apply retroactively its reductions. Among them, it's the purpose of the amendment that was passed, the magnitude of the change in the guidelines, and certainly the difficulty in applying the amendment retroactively. And those are factors that we consider, and we certainly considered at this time, as well as all the other data that we have and had, not only on retroactive with crack, but with regards to the number of people that would be involved here.
And if I might interject, you're talking about should these new rules apply to inmates who already are in prison. How many inmates would be affected potentially by this?
We think that it's in the neighborhood of about 40,000 people. It would be inappropriate for me to give you an exact amount because some of these individuals have qualified for good time, others have not, of the 15% good time behavior that they get the reduction on. But our data is particularly good, and I think we're very close to the 40,000 in that neighborhood. It will affect a lot of individuals. What this does mean, though, is we have to realize that this are individuals who are eligible. It's going to be up to the individual judges after making individual decisions as to whether these are defendants that they feel are appropriate in each case to receive the reduction. And so what we have done is facilitated the ability for them to have a reduced sentence, but in the end, the judge, considering public safety and other matters that the judge considers, the 3553A factors, is going to make a decision as to whether to reduce those sentences for each one of the defendants eligible.
So I want to ask one question about the commission's process. My understanding is after the first vote, the staff essentially did what's a retroactivity analysis. Commissioner Barco, if I could turn over to you, can you summarize what the staff produced as part of its analysis?
Sure. So it's the data that Judge Hinojosa has already mentioned in terms of anticipating the numbers of people who would be affected. Also, we looked at the recidivism study that Judge Jackson had mentioned, so we could look to see what happened with the retroactive application of the crack guideline amendments to find out what whether that had a hit on public safety, and we found that they didn't recidivate at a higher rate when they got the benefit of it. We again put out a new round of notice and comment, and this time we got 60,000 letters and comment from a variety of organizations and individuals again, and again mostly in favor of applying this retroactively. And we held another hearing, this time specifically on the question of whether to make the amendments retroactive, and again had the stakeholders who felt very strongly about the issue.
So let's move ahead. There was another hearing in June where the Sentencing Commission heard from witnesses, much as they did for the first time, to decide whether to apply the new guidelines to people who had already been convicted previously of drug trafficking. So let's take a look at a video clip of that hearing.
Today, we consider an issue that is more difficult. As required by statute, the Commission is now considering whether the amendment reducing the guideline levels should apply retroactively.
Last week, the Criminal Law Committee discussed at length whether to support the retroactive application of the proposed amendment. In our deliberations, we wrestled with many difficult issues. After careful thought and significant evaluation, the committee voted by a large majority to support making the proposed amendment retroactive only if the courts are authorized to begin accepting and granting petitions on November 1st, 2014. Second, any inmate who is granted a sentence reduction would not be eligible for release until May 1st, 2015. And the Commission, third, helps coordinate a national training program.
We believe that retroactivity of the drug amendment should be limited to lower-level, nonviolent drug offenders without significant criminal histories.
Doing the right thing itself has power, and we should not underestimate the power that taking even a modest step to reduce unfair sentences can have for an inmate, for his family, and also for our communities.
Many of the proponents of sentencing reductions and retroactive application portray those who've received prison sentences as victims. They're not. The real victims are the law-abiding citizens who live in the neighborhoods that have been ravaged by drug crime and its collateral consequences.
I'm a conservative Republican, and I would note to you that there's a growing movement among conservatives to to rethink the long sentences and the excessive costs, not only in human terms, but in fiscal terms for the states.
Commissioner Barco, we heard quite a range of viewpoints just even in 2 minutes. What did you find were the most important arguments for and against?
So the individuals and organizations who filed comments in favor pointed out that for all the reasons that we thought we should reduce prospectively, that all those same reasons would apply to giving retrospective relief. That as a matter of equity, it wouldn't make sense to treat the two groups differently since the same arguments applied. Because the prisons are over capacity, it would have an enormous benefit if you gave retroactive relief, because we could start releasing some of the people earlier who are currently there, and that would then free up those resources and those dollars to spend on the other law enforcement priorities and objectives that could be that might be a better use of the money in some of these cases. And then they also highlighted for us that judges would be well positioned in each individual case to make sure that it was appropriate to give retroactive relief to that specific individual, because they could look at their prison record and their behavior there, and they could make the assessment whether or not it would be okay for public safety. As you saw from the video, we got some nuanced comments. The Department of Justice would have us grant retroactive relief, but only to a subset of people that they had identified, people that had very minimal criminal history. The administrative office was also in favor of retroactivity and full retroactivity. They just asked us to delay the implementation. They had asked for 6 months to give time for judges and probation to get ready. And then we did get comments of individuals who were opposed to retroactivity. And specifically, some of the law enforcement commenters had pointed out that the release of large numbers of people could have an impact on public safety. So we took all of that into account in crafting our retroactivity decision, which took into account all of those things and came to the conclusion that we should give full retroactivity, make everybody eligible to go before a judge, but to delay the implementation to take into account those public safety concerns.
Judge Harris, was this vote also unanimous, and what led you to make your vote the way you did?
Yes, the vote was unanimous. It was taken in last July, and what we decided to do was to make it retroactive, but in a way that carefully balanced the concerns of public safety and the administrative concern of the courts and the Department of Justice in implementing the retroactivity by making the retroactive amendment not effective until November 1st, 2015. In other words, judges would start considering petitions after Congress had a chance to look at the amendments, and so the amendment went into effect on November 1st, 2014, in the sense that judges could start to look at the petitions. But the amendment was 1 year delayed until November 1st, 2015, before anyone could be released. And many of the factors which led us to vote for the prospective changes also supported the retroactive changes.
And what are people hoping to gain by this year's delay?
1 year delay, thanks, because that was really an important part of it. As you heard, the Criminal Law Committee wanted a delay, and we actually created a delay longer than what the CLC or the Criminal Law Committee asked for. Why? First of all, this would, in our view, promote public safety in 3 ways. First, it allows judges more time to consider the initial influx of motions for reduced sentences. So retroactive application of this amendment does not automatically entitle anyone to a reduced sentence. And I want to say that this is a big country, as Judge Hinojosa said, so that the burden of this is significantly different depending on what part of the country you're from. And we heard in particular from the border judges about how many motions that they expected to have to hear. And this is an important part of public safety, to have a judge look at each one of these petitions. The second is the delayed implementation ensured that the Bureau of Prisons has enough time to give every offender the usual transitional services and opportunities that help increase the chance of successful re-entry. For example, halfway houses and transitional programming. It's important, we heard from the last time around, not to just dump people on the streets. They need the same transitional services that all offenders get, and it was important to make sure that BOP, Bureau of Prisons, has enough time to implement it. And last, and very importantly, we needed to give our probation officers time to plan. Look, these are a lot of people. As you heard from Judge Hinojosa, close to about 40,000 people who will be affected. They need to be able to plan and create re-entry plans for each person who comes out. So this process has started, but no prisoner will be released early based on the amendment until November 1st, 2015. I should add that the Congress did not act to change the guidelines, so it did go into effect, as I mentioned, in our cycle on November 1st.
Judge Jackson, at the courthouse level, how are you responding to this?
Well, I personally am not going to be that affected because as a relatively new judge, I don't have a number of people that I've sentenced to are serving time for drug sentences. But the District Court for the District of Columbia is following a practice that is very similar to the one that we implemented in 2007 for the crack retroactivity reduction. That is, the court has received a list of potentially eligible offenders from the commission, and the commission has these lists available for every district. The court has formed an ad hoc committee that includes judges, representatives from the U.S. Attorney's Office and the Federal Public Defender's Office, and probation. And this committee is going to manage the process within our district. They're going to meet regularly to receive and review the applications or the initial requests from inmates. And then as far as how the process will work practically, my understanding is that the list of offenders has been prioritized by release date, so that the earliest to be released absent the reduction are going to be considered first. And then the probation office is collecting information about each individual, pulling their records, determining what the offense, their criminal history, and then getting information about their performance in prison, and combining all of this and writing a memoranda with respect to each person. And this memoranda is going to be forwarded to the Public Defender's Office and the U.S. Attorney's Office for review. And hopefully the two sides will review the memoranda and come to a consensus as to whether or not to recommend to the judge that this person receive the reduction. If that happens, then the Federal Public Defender's Office will file a motion on behalf of that individual, and the judge will at that point have all of the documents and be able to make a determination. If the FPD and the U.S. Attorney do not agree, then there'll be litigation. And the judge will have to decide whether or not, under those circumstances, to grant the reduction. But in any case, with respect to every offender, the judge is going to make the final decision as to whether or not this person is entitled to a reduced sentence.
And if I may ask, are the two judges, are there any significant differences in your districts, or is what Judge Jackson described pretty much what you're doing?
I actually did live through the crack reduction, and it's almost exactly the same as the way this worked. I was actually involved in setting that up, and I have to say from personal experience, it is a big country and things are different, but there are very few cases that actually came to me disputed, and then you'd resolve them. Few of them hit the circuit court, but I would say the overwhelming numbers were resolved by consensus as to what was the appropriate outcome. And a critical thing, though, is that we also have to get the disciplinary reports from the prison. So it is by no means a rubber stamp. Everyone's looking at what's happened, not only as part of the crime, but also what happened afterwards.
Judge Hinojosa?
And well, in our district, we are seriously affected with regards to the numbers, and so the judges are varying as to how they're handling this, but I have to say the probation office is really preparing a report on every single one of these based on when they're likely to be, their release date is, and giving us reports on every single one of them, even if they haven't filed motions. And I'm sure that each one of the judges will seriously look at all of these and do it timely so that there will be community confinement and or home confinement. And also, we'll have to keep in mind that the ones that are non-citizens will be deported after having served their entire time and not have community confinement or home confinement for rehabilitation purposes.
And Judge, does this complete the Commission's work on drugs trafficking or drug sentencing?
No, and I think some of us made it quite clear when we voted for the drugs -2 as well as the retroactivity that we continue to urge Congress to look at sentencing reform in the drug trafficking area. This is, as we've heard before today, 50% of the defendants in federal prison are in because of drug trafficking cases. We operate by consensus, and we have sent a report to Congress on mandatory minimums. There was not a consensus that we recommend that we do away with mandatory minimums, but there was a consensus in agreement by all of us that Congress should seriously study reducing the mandatory minimums at the 10 and 5 year levels to another level based on recidivism studies. And we also had a strong consensus that Congress should study whether to increase the safety valve criminal history points from 1 to possibly more. I think we are encouraged by the fact that there are bipartisan pieces of legislation that have been introduced that basically mirror these recommendations. And at the same time that Congress is paying attention through some other bipartisan pieces of legislation for rehabilitation while a person is in prison, so that when they get released, perhaps we have done a better job of releasing them in a way that they will not be recidivists again. And so I think we're encouraged by that, and I'm sure the Commission will continue to work very hard with Congress as it did with crack to try to better the system.
Commissioner Barco, Judge Sarris mentioned right up front that there's a new amendment cycle every year. Tell us about the current cycle, what's on tap now.
Sure. So we're in the middle of that amendment cycle, and some of the priorities that we have for this year are examining our fraud guidelines to see if any amendments are needed in that context. We're doing a multi-year study of recidivism in the federal prison population and federal offenders. We're also looking into this question of how you define crimes of violence, which is relevant for our career offender guideline and also comes into play in statutes like the Armed Career Criminal Act. We have to, it's a term that has really perplexed the courts, and so we're looking to see if there's a way that we could help bring clarity or to make recommendations to Congress so that Congress could do something like that.
Well, this is my last question before we open it up to the audience. Judge Sarris, we've looked in depth at this year's drug sentencing reform process. What broader lessons might there be for the audience here about the Sentencing Commission?
Yes, I would say there are 3 big takeaways. The first is that the Commission is committed to data-informed sentencing reform. In other words, we look at the data. We have an excellent staff that looks at every judgment that's been issued across the country, and we learn things from that, whether it's on the recidivism for the crack offenders released early, or whether it's on the trial rates or cooperation rates or any other range of issues. We look at the data, and we operate based on evidence and input from stakeholders. Second is we are committed to access and transparency in the process. We're very lucky. We now have technology that didn't exist a decade ago. Our data goes up on the website. We try to be transparent in the hearings about the kinds of things that we're thinking about. We don't operate in a bubble here. It's very important for us to explain why we do what we do. And finally, we hope to be very responsive to the public, to Congress, to the judges, to the defense bar, and to the prosecutors. I mean, we are, some people say we're the crossroads of all the branches of government. And so while we're physically located right here down the hall, upstairs, and we have our hearings here, in every sense, we work with all 3 branches of government to try and create fair, consistent, and proportionate sentencing.